case in court here in Abuja of a gentleman lawyer who was said to have been asked, or well, some version of the story says ordered by a judge to kneel down in court on account of the claim that the said judge had mentioned that the lawyer was rude to him, had gone viral with several versions of that story flying all over, particularly on the social media. However, our reporter who was on the ground right in court that day said what had happened was the judge called out the lawyer and mentioned that there was a better way to speak to the court, as it were, and then he asked that he should kneel down. However, again, the gentleman lawyer did make a case for how that such an action would, as it were, rub off negatively on his human rights, and the judge understood and said, well, that was a better way to speak to a judge. And for many people, perhaps everyone who was in court that day, that matter had died a natural death at that point. However, of course, it's 2026, social media took it up, and then several elements put a spin on it, and it became a talking point to the point that we saw several reactions following days after the incident in particular. That has now also, by extension, raised concerns as to what are best practices, are there standard protocols as to how lawyers should conduct themselves, especially in courts, in front of a judge or magistrate, as the case may be. That's the fulcrum of our conversation on the program today. This is Scale of Justice on Global Television. I am Uyi Agmofwegbe. My guest today is Akintayo Balogun. He's a lawyer and a legal analyst. I'd like to say a big thank you to you for coming on the program.
Thank you very much, and good evening.
Great. So let's begin first off by looking at that incident in itself. Some people describe this as dramatic. Others say, well, really, there was nothing spectacular. It was just people taking the whole thing out of context. I'm not sure if you were in court on that day, but I'm certain you have read the story and you have heard several angles to that incident. What have been your thoughts?
Okay. Well, since I've been practicing as a lawyer, this year makes it my 16th year as a lawyer. I've actually never heard or seen something like that. So
when you say something like that, put the context to it.
When I say I've not seen something like that, a situation where a judge would ask a lawyer to kneel down in court or something. We have seen other actions of judges, such as a judge instructing a lawyer to remove his wig.
Okay.
You know, at some points where probably they have done something that is contemptuous to the court, you know, told them to remove their wig or to step out of the bar, you know, just to say something, but not to the extent of saying that a lawyer should kneel down. I've actually never seen or heard of such. But then I was not in court. Whatever I know about it is what we heard from the various social media platforms, and as well as the statement that was made by the NBA president, you know. But then for me, I would say that we should not take that action out of context. Let us really understand what got the judge to that point. A judge would ordinarily not say kneel down. You know, I believe there was a level of provocation that got the judge to that point. There was something the lawyer said, or probably the way he addressed the judge, the way he spoke, his choice of words were not proper. And that's probably what got the judge to that point. So there's a duty on us as legal practitioners to ensure that we don't get on the nerves of judges and magistrates. You know, it's for a judge to get to that point, I believe, I wasn't there, but I believe that it's like you have pushed him to the wall and you got him to the point that he had to say, come and kneel down. So that is where we lawyers need to, not just lawyers, including litigants, because the provocation of the judge that day was not just what the lawyer said. He was provoked both by the lawyer and even the lawyer's client. So there was a way, there was a front they pushed to the court, which aggravated the issue. So we lawyers and even litigants too, we need to adjust the way we do things, and then on the part of the judge. Now, a judge can punish a lawyer, but then...
Is that a standard practice?
Now, let me explain. It's not to say, oh, you are doing something, this is it, then I will just punish you. No, there is a procedure to it. When a lawyer probably does something wrong right in front of the judge can cite that lawyer for contempt.
Right.
That is the first thing. The lawyer is cited for contempt. And then after that, a kind of proceedings, relating to that contempt kicks off. It could even kick off immediately, there and then. It could be another judge, assigned to another judge. This is what transpired, and all that. But you cannot just give a verdict. What happened there was more or less like an outright verdict, saying kneel down. A judge can say you should kneel down, but it's after you have been proven guilty or you have been proven to be in contempt of the court. So the court can decide that the punishment I want to give you is that kneel down before the court. We had a case last year or 2 years ago where a lawyer was cited for contempt and a proceeding started immediately and the lawyer spent 1 month in prison. That was the decision of the court there and then. So the judge has that discretion to determine what the punishment should be. But the punishment cannot be the first thing. It has to be after the lawyer has been cited for contempt, and then there's a contempt proceedings, and then you find him guilty and you take an action. So
that's the safe way to put it differently, that in this case it was a matter of placing the cart before the horse.
Yes, to a large extent. That's actually what happened.
Did the judge overreach in your own assessment?
Well, like I said, I don't know what
exactly transpired
that got the judge to that point. But the truth is that it was like putting the cart before the horse. Let's say the lawyer did something terribly wrong. You don't just punish him straight away. You cite him for contempt first, and then there is a procedure before you can now decide. It's the discretion of the judge. The judge can decide, okay, it's my discretion. I want you to kneel down as a punishment. I want to send you to 1 month imprisonment as a punishment. It's at the judge's discretion or the magistrate's discretion. So what happened there was more or less like putting the cart before the horse.
I just want to ask this, of course, more like an ancillary question to the first one, right? Is it appropriate or otherwise for a judge to punish, as it were, a lawyer for his client's offenses or excesses? In this case, now you see the person that is visible to the court is the lawyer. Right.
In fact, a lawyer that is not properly dressed, a judge will say, I can't see you. Now, it is wrong for a litigant to be in court and he's talking to the hearing of the judge when the judge has not given him that's not giving him the place or the right to speak. Whatever you want to say, that is why you have a lawyer. You have to communicate through your lawyer. Everything, except if you are giving evidence, you have to talk. That is where, okay, whatever you are saying is being recorded by the court. But the reason you have a lawyer is that your lawyer takes everything from your mouth, everything that should proceed from your mouth comes through your lawyer. So ordinarily, a judge a litigant should not be allowed to speak in court to the hearing of the judge, except where the litigant is giving evidence. So you see, punishing a lawyer, based on the action of the litigant, for me, it's somehow, ordinarily, if a client is misbehaving, if the litigant is misbehaving in court, the best thing is for the judge or the magistrate to tell the lawyer, talk to your client, put your client in order, tell your client the right thing to do. That's actually the right thing that should be done. we have seen cases where litigants misbehave in court, where they talk anyhow, they do what they are not supposed to do, and the judge will just tell the orderly, march that person out of the courtroom, tell that person to leave. But you know, in a situation where you are a lawyer and you are unable to tame your client, you are unable to correct him, you are unable to put him right, it's better the lawyer exonerates himself and tells the court, this person seemed to be beyond my control. Let the court take an action on him. But I wouldn't want to say that it is proper that a judge should punish a counsel, a lawyer, for the action of his client or a litigant in court. Yes.
I'm sure you have read the reaction of your association, the Nigerian Bar Association, for example. What was your assessment against the backdrop of this particular event?
Well, what the president said was there is no place, that does not have a place in law. You know, he kind of condemned the action. But then, well, that's his opinion, of course. Of course, that's also the opinion of the NBA because he speaks for the NBA. But then I would have said that the best approach to it would have been, this is how it is supposed to be done.
Right.
Yes, a judge can tell anyone to do anything. But the thing is that you don't just say it in vacuum. It should be done properly. If a lawyer is cited for contempt and is found guilty of that act, it is the discretion of the judge to say, this is how I want him to be punished. This is the punishment I want him. The judge can decide to say, let him pay a fine to the court. You know, it's at the discretion of the judge. But then, like I said earlier, the punishment should not be the first thing.
There are people who believe that this instant case or incident was not a standalone sort of, if you like, event. They have the feeling, I mean, by their own assessment, there must have been a build-up to this. That judge had seen something over time at several proceedings, and then this became more like a situation where things came to a head. But let me move you away from the courtroom, so to speak. We're seeing lawyers who speak after proceedings, for example, they're talking to journalists, and they are giving their assessment of maybe a court order or a verdict or whatever it is, and you see them say some things that are not necessarily or essentially palatable, some things, sometimes in some cases, unprintable things about the court, about the specific judge in this matter and things like that. Do you think some judges or some members of the bench take that into consideration the next time they encounter such lawyers, for example?
Yes. You see, one of the things that the legal profession in Nigeria, you know, is really, really discouraging is this issue of making comments about a suit that is still pending. So, I think last year, no, not last year now, when lawyers make comments on cases that are pending in court, you say things that has the capacity, you know, to sway the mind of the judge either way. You make comments, you know, say things that are ongoing. You know, many times, yes, I know, the journalists are actually culprits because they are the ones that throw the questions to the lawyers. You know, as a lawyer, you should be able to say, you should be able to tell the journalist what you can say and what you shouldn't say. So, it is okay. In fact, personally, I've come to the point where when a matter is pending, it's best to avoid, you know, communication.
Speaking to the press.
You know, it's best that when the matter is concluded, yes, you tell the press, yes, this is the decision of the court, this is this, okay, we don't agree, we've already applied for the judgment, we are taking this matter on appeal, you know, and all that. There was a time matters were pending before Honorable Justice Omotosho of the Federal High Court, and comments were made like this. Comments that were very strong, comments that were condemning the actions of the judge, you know, comments that that had polluted the mind of the court, such that when the court heard it, and the court came back the following day, that was where the court started from. You made comments. Your comments alone, they are already giving me a bad perception about your person. You know, so that is why the CJN 2 years ago said comments like that should be avoided. Avoid discussions, avoid things that has a possibility. Well, I don't want to say it is okay to just say, okay, this is what happened in court today. Yes, that is where probably some people try to restrict themselves. You know, okay, this is what transpired today. This, they called certain number of witnesses, they testified, you know, just to give a fair. But you see, if you look at the mind of the judiciary, it is best advised that you don't even do that. Leave all those. Once judgment is delivered, you can say everything you want to. You can even read your notice of appeal, what you intend to have as your ground. Right. You can bring it to the press, but not to begin to make comments that has the capacity to dissuade the mind of the court either way.
You know, I speak to lawyers on the record a lot. Some of them would tell you in confidence that, look, judges too, in many cases, have dropped the ball in the manner of speaking. And as such, it has now become a case of he who must come to equity must come with clean hands. And as such, it gives some lawyers that sort of, if you like, temerity to look at a judge in the face and speak to them. For example, I spoke with a man, not a lawyer, a very far senior colleague in this profession, and he told me a time there was when he was growing up in this country where you couldn't even see a judge on the streets. A judge would live on same street as your father. You just know this man is a lawyer. You are never sure that he's a judge or not, but the man is a judge the entire time. He was saying back in the days, judges didn't have social life and stuff like that, so it was near impossible for you to drag a judge into a social matter or even have conversations about a judge away from the courtroom. But fast forward to, the turn of the new millennium, you realize that we now see judges going so social, and judges are implicated in certain things that you can't be proud of, and things like that. Have we not really dropped the standards? Isn't that the reality we're dealing with right now?
Yeah, actually, the standard has been that once a person becomes a judge, you know, the level of your association with people would have to drop. Yes, because these people are the litigants.
Right.
You don't know who would appear before you. You don't know whose case will come before you. You don't know who they are trying to get, you know, and all that. So immediately, once a person becomes a judge, it's like you withdraw from the public.
You become circumspect.
Yes, you withdraw from the public. The only place where you can be seen and where you can be heard is in the courtroom. You know, just today, I saw a comment online that was made by a retired judge. You know, and the comment had to do with the incidents where a litigant was granting press interview right in the courtroom yesterday. You know, he made a comment about it on social media. And I was very impressed, and I was like, it's good to have someone like this who can make statements like this on social media. You know, 2 years ago, he cannot do that. Probably his account self on social media was dormant.
Right.
You know, but now that he's retired, he can make comments like this, say this is right, this is wrong. So that ordinarily should be the standard. Should be the standard. You know, recently too, I was having a discussion. I saw a post on social media of someone that I know. So I called a mutual friend. I said, come, I thought this person has been appointed a magistrate. He said, yes, any problem? I said, look at what I saw on social media. And he was like, he didn't say any other thing. You know, that's actually the unfortunate situation that we find ourselves nowadays. You still see where some judicial officers are still active on social media, still make comments, you know, and all that. You know, we have had situations in recent time where, due to comments like this, someone gets to court. He would say court should recuse itself because the mind of the court is already biased and all that. So that is
that a problem? When we see that happen in several cases. Nnamdi Kanu comes to mind, for example. Is there anything wrong with that? If you ask a judge,
what I'm saying, no, it's not wrong. If you ask a judge to recuse himself, if there is a definite reason why you are saying
for such a request,
yes, there's a definite reason. For example, now I just made reference to someone a judicial officer who made a post on social media. Now, if something comes before that judicial officer and it has a link to that post, I have the matter before that officer, I would tell the court immediately that we are not comfortable continuing this case here because the court made so post on social media which we are not comfortable with, and we would humbly apply that the court should recuse itself, let the file be sent back to the CJ for reassignment. We can do that.
Right.
So that is why, to avoid situations like that, that is why, let me say, 99% of judicial officers are not seen on social media.
Right.
If you go to their, you will see that many of them had opened their account long ago and abandoned. It's mostly inactive. So it's just that in the midst of this, there are still 1 or 2 persons that would still not be doing things right. You cannot have 100%. You would still have 1 or 2 persons that would be breaking or that might have been found to break the code of conduct.
Right.
Yes. So it's but then the standard should be maintained. We should see judicial officers as persons a bit higher than the ordinary and should not be seen making comments, saying things, not allowing themselves to be put in a situation where the other person feel biased. You understand? So that's the situation with our judicial officers. I'm hopeful that we can again maintain the standard that we once had of judges and magistrates in some 20-30 years ago.
As we wrap things up now, in 1 minute, I mean, you've been to courts for, a long time. From what you see over time now, would you say there's a strain between the bench and the bar overall? I mean, nothing is perfect, of course, but when you look at all of the factors.
Well, I wouldn't say there is a strain. I wouldn't say there is a strain, but then one important thing is we must ensure that we maintain that standard relationship. We maintain that both communal, both symbiotic relationship. We are not parasitic, you know. We because the truth is, lawyers cannot do without the judge, and the judge too cannot do without the lawyers. Same thing applies to magistrates. We cannot do without we just must work together. It's like the relationship between the cow and the egret. You know, the cow needs the egret to clean up his body, where his hands his hands, let me use the word hands, cannot get to, and then the bird also needs those sticks to eat and grow up. So that is a relationship,
Some sort of interdependence.
exactly. So we both need each other, but then we should always know where to draw the line.
Right.
We should always know where to draw the line. You know, we're in a system where we hear people brag that I know the judge. You know, it's a dangerous statement. It's a terrible trend. Unfortunately, I know the judge. This one says he knows the lawyer, but me, I know the judge. It's a very, in fact, it's something that should not be heard of.
I almost find a way to check it.
Yes. You know, even if a statement like that comes out, it should be investigated immediately. So if there should be any relationship between the bar and the bench, it should be that symbiotic communal relationship where we see the judge is only seen in the courtroom.
Without anyone trying to undermine the other.
Yes, without anyone trying to undermine the other.
Incidentally, that's the much time we're allowed to take in the course of this very interesting and incisive conversation. I'd like to say a big thank you to you, Barrister Akintayo Balogun, who has come here to share with us today on the program. Well, that's how we'll leave it here on Scale of Justice on this edition of the program. On behalf of my colleagues who have made this broadcast possible, I'm Muyi Agumofwegbe in Abuja, Nigeria's capital.